So in this video, we're going to talk about the two dominant narratives related to sue culture in the United States and how they are flawed and why insurance companies oftentimes love the flaws. So we have a group of people that are willing to sue under circumstances that are sort of frivolous and ridiculous. This group of people will, create injuries that aren't there or try to. They'll throw themselves down flights of stairs. They'll sue their employer for kind of wild accusations of discrimination, those kinds of things. That's Group A. So Group A destroys the system by sort of encouraging Group B that they're justified in feeling the way that they do, because Group B doesn't want to sue under any circumstances. They feel like they don't ever want to be looked at as a victim, and that anybody with a backbone wouldn't sue under the types of circumstances that are oftentimes warranted in this realm. So a great example of Group B that is currently all over the news is a prospective Camp Lejune plaintiff that I know through a couple people. So Camp Lejune is a military base in North Carolina that had a gigantic lake water source on it where they would conduct a lot of military trainings. And it turns out this water was filled with toxic chemicals. And these toxic chemicals have caused tons and tons of people to get different kinds of cancers and dementia and things that have shortened their lives significantly. So there's a gigantic pot of money available to these people that were at Camp Lejune from the late 50s to the mid 80s or so. So the guy that I know, he's in his 70s, older guy, might be pushing 80. He was in the Marines, so he's, a conservative guy, definite Group B guy, does not ever want to be seen as a victim, doesn't ever want to take any handouts. He's had a type of cancer that meets all the criteria of someone who was at Camp Lejune and got the cancer, very likely because he was at Camp Lejune. He was told by a nurse, a VA nurse, that this was just a cash grab. The whole thing is just lawyers trying to make money, and any additional money that's even available, the VA is just going to recollect it to pay for all the medical liens associated with his cancer treatment. So in his mind, he's like, this is stupid, right? And another big influence on his mind at this point is how crushed he got with advertising related to the claim. So a lot of the Camp Lejune stuff that people have seen is very scammy. The whole feel of it just feels kind of dirty and greasy, because a lot of the outfits that are marketing it are dirty and greasy marketing companies that are trying to get people to sign up to grab money. And I mean, that's present in just about every industry, but guys like him are not going to respond well to that. And it's really unfortunate, because like that money is just going to either go into somebody else's pocket or get saved by the government, and we all know how good they are at spending money. So these are very unfortunate situations when you have something like Camp Lejune that created gigantic problems for a massive amount of people, and now you have guys like this old school guy. He's a very good guy. He ended up working for himself. He's very successful. He's self-made. He's proud of his time in the military, but he wants to leave it alone because of the perceived shame of pursuing a claim, right? And that's not just like what's lost on a lot of people, I think, is that this is like this whole thing, plaintiff's personal injury work, it's very akin to civil rights work. People get severely injured due to the fault of somebody else, and then to compensate these people, we come up with a dollar amount, whether it's 12 people on a jury, or it's an insurance company and an agreed upon settlement, or the government and agreed upon settlement, whatever it happens to be. But this creates a safer world to live in for everybody, because nobody wants to be on the hook for these gigantic piles of money. So it's naturally going to have the consequence of making a safer world, and a world where people take responsibility for their actions. So that's a good thing. And most injury lawyers with any level of integrity, they don't want Group A clients. Like, nobody wants a Group A client. They want a Group B client, ironically, because those people are going to be honest. They're going to show up when they need to. They're going to do what they need to. to pursue their case in a reasonable way, and they're not going to lie to you, right? Because the Group A clients are more likely to lie to their lawyer than the Group B clients, to exaggerate their injuries or, you know, that kind of a thing. So it creates problems around the whole bend. And so a perfect example of a case that is used as an example of how frivolous and inflated plaintiffs' jury verdicts can be is that there's this case from the 90s where a woman got a coffee from McDonald's and spilled the hot coffee on her lap. So as it turns out, the lid on the coffee was not secured by the employee. The coffee was being stored at temperatures that were way outside of what was ever reasonable to get a coffee temperature-wise. And the lady spilled the coffee on her lap because of the unsecured lid and got so severely burned that she had to get skin grafts related to the injury. So she did suffer a significant amount of harm as a result of McDonald's storing their coffee at a temperature that was way too hot to consume and then supplying her with a product that had a lid that was not secure and spilling it all over her lap and getting so burned that she had to get skin grafts. She ended up getting over $1 million at a jury trial. And these kinds of verdicts are used as leverage for insurance companies when they're training adjusters and when they're talking to people when they're trying to pass tort reform at the state or federal level to decrease these kinds of settlements. And they love this kind of talk where it's like, oh, can you believe she spilled coffee on herself and she got $1 million? Can you believe what world we live in that this kind of thing could happen? Insurance companies are clapping their hands at this because they are thinking about saving money, which is what all companies are going to do. So, and the reality of even that particular case, and I'm sure there's dozens of examples of cases that had way outsized numbers settlement-wise or jury verdict-wise that were inflated and were outsized, but there's just as many cases that had a justified way larger amount, right? So like the way these things can swing in either direction is always going to be problematic. And if you have competent people that are in charge of it, it usually shakes itself out where it's supposed to be on both sides of the case, the plaintiff side and the defendant side. You know, the truth generally kind of works itself out over the course of a case. So that's what you want. So another example from my personal experience with being a Group B type person is when I was a kid, I was severely injured at my grandparents' house. And the injury was the result of what you could classify as negligence of the way that my grandparents were operating in the house. And so I'll spare all the gory details, but when the event happened where I became injured, as I was kind of healing up from it, I remember my parents saying repeatedly, "We'll never sue. We're not going to sue. We would never sue." And I just remember thinking like, yeah, I don't want to be like the kind of person who would like sue their own grandmother over an injury. And my parents and myself, like, we love my grandmother, and we would never want to, you know, parade her around into court and make her testify about her grandson suffering some traumatic injury that was life-altering and life-threatening and the whole bit. But the reality of how this works is that my grandmother had a liability homeowners insurance policy that was in place, and she contracted with her insurance company to secure a certain dollar amount that was available as a pot of money to be paid in the event that something like this happened. So that contract is what controls that situation. It has nothing to do with my grandma. I mean, it does, but it doesn't, right? Like, she effectively took the risk of that and assigned it to her insurance company, and she pays a monthly premium to enjoy that privilege, right? And that's what she's paying for. So as it turns out, the insurance company was willing to pay the policy limit almost immediately because of the nature of the injury, so we didn't have to sue. But in the event that we did, it would have made perfect sense to. Everything having to do with that lawsuit would have been a negotiation with the insurance company or a trial where my grandmother would have been fully represented by the insurance company, and it would have been what it was. She would have been able to say what needed to be said, and she actually was ironically encouraging my parents, if you need to, please do it. You know, because it's not like we're going to collect on a judgment against my grandma. I mean, she's, you know, my grandma. So it would have been what it was. But now that I have a deeper understanding of how the whole system is set up as a result of my experience as a lawyer, even if it's your own grandmother, it makes sense to look at it from that perspective of like what's available, right? So yeah, that one hits close to home, and So the solution to the problem is understanding how the system functions, understanding what insurance policies are and how they work, understanding what insurance companies' duties are relative to the person that they're insuring, and that money is the main way that injury victims are compensated. So a lot of damages you cannot put a price tag on, but this is the only means, again, that we have to solve the problem of an injury. And it's better than the alternative of nothing, right? So holding people responsible through these monetary avenues is it. We don't have a system, we don't have a world set up where it's an eye for an eye anymore. So this is the alternative.